Good evening. This is Shanette Thompson from Kingsley Napley. We are live today and we are engaging in a webinar on female genital mutilation. And we are looking at it from the perspective of both doctors, your obligations, your duties and lessons learnt from the case law, and also patients. I have an extremely special guest with me, Zoe Johnson QC from QEB Hollis Whiteman Chambers. Hello Zoe, and thank you very much for being with us.
Hello Shanette, nice to be here.
Zoe has a really impressive practice and I'm going to turn over to her to give you a little bit of a background as to what she does.
Well, I have been a criminal barrister for almost 30 years now. I've specialised in the most serious criminal offences, both prosecuting and defending. But perhaps for our audience today, the aspect that is perhaps most relevant is crimes with a medical aspect to them. So that will include baby shaking cases, anything with a psychiatric element, medical manslaughter, gross negligence manslaughter. I've done a number of those cases. And of course, the reason why I've been invited today is that I represented Dr. Dharmasena, who found himself the first person to be charged in this country with an offence of FGM.
Thank you very much, Zoe. Just to say at the outset that this webinar is not to discuss our own personal views in relation to FGM. This is a topic that is going to be interactive to give you the opportunity to ask any questions of us about any duties you may have if you are in the healthcare field, and equally just to air the discussion around the topic. So let's start off with some facts and figures first. What is FGM? The World Health Organization classifies FGM into 4 categories. The first category involves the removing of all or part of the clitoris. The second category relates to the removing of part or all of the clitoris and also the labia minora, which is the inner folds of the vulva. The third category relates to the narrowing of the vaginal opening by creating a seal. And the fourth relates to other procedures which are equally non-medical, so things such as piercing, scraping and cauterizing, so burning the area. Now there are clearly complications of FGM, regardless of who it is conducted by. They can include things such as pain, which is constant, pain or difficulty having intercourse, repeated infections, which unfortunately can lead to infertility, bleeding, cysts, abscesses, problems passing urine or incontinence, and also problems during labour and childbirth, which was one of the issues which arrived in the case that Zoe is going to be talking to us about in more detail in due course. Now, some more facts and figures. NHS England reported some figures between April 2015 and December of 2017 that there were 15,390 patients with FGM who were treated in the NHS. Equally, we've had some more figures since I put together these slides, so I'll give you some more information. That there are about 5,000 women and girls who are subjected to FGM in the UK on a yearly basis. And it's thought that there are around 137,000 women and girls estimated to be living in the UK who have had FGM, and that there are potentially another 144,000 women who are thought to be at risk. Now, the highest incidence of FGM seen in the NHS were type 1 and 2 that I described to you just a short while ago, and that the average age of the patient when they first present to receive treatment was around 31, and those figures were taken between April 2016 and March of 2017. Now, who estimates that there are around 200 million, I beg your pardon, women and girls alive today that have undergone FGM in the 30 countries where the practice is mainly concentrated. And the rates of FGM are increasing, and are increasing at the current rate. If they do so, it is predicted that around 68 million girls will be subject to FGM between 2015 and 2030. Now, given these figures, one of the reasons why we are having this webinar, that it is very important that healthcare practitioners in the UK have a good understanding of FGM and their duties in relation to it. Now, quite clearly, FGM is illegal in the UK, but there are a number of jurisdictions where it is legal, and that's why it is important for healthcare practitioners to be aware of their obligations. Now, some of the countries identified by the National FGM Centre where the practice is legal, Colombia, but if it results in a death, it constitutes femicide, Kuwait, the Maldives, and Singapore. There are some countries which have a list examples, not a list. There are some countries which have no specific law prohibiting certain types of FGM, and I shan't read through all of that list, but you can see them on the screen there. But just as an example, in Indonesia, it's illegal to perform grave types of FGM. In Nigeria, it's criminalized in some states. In Sudan, equally, it's illegal in some states. And in the United Arab Emirates, it's illegal to perform in government hospitals, but it can be performed in the private sector. Now, I am going to turn over to Zoe now to give us some insight into the legislation and the law around FGM.
Well, the Act which is in force is the Female Genital Mutilation Act 2003. As you know, there was an earlier Act. It's a 2003 Act that we have to concentrate on. And it's Section 1 of that Act which sets out the elements of the offence. A person is guilty of an offence if he excises, infibulates, or otherwise mutilates the whole or any part of the girl's labia majora, labia minora, or clitoris. Now, those three words are critical, and let me just deal with them at this stage. Excises is relatively straightforward. That means cuts. And indeed, the legislation was designed to reflect the WHO 4 categories of FGM that Shannon has just talked about. So excise is designed to deal with types 1 and types 2. The person is guilty if he or she infibulates. Now, that was at the heart of the Dharmasena case, and I'll come to that in a bit more detail in due course. But infibulation is again the sealing of the vaginal opening and indeed the urethra so that it is in effect just a pinprick opening. But as I said, I'll come back to that when we talk about Dharmasena. And the other word used in the Act is mutilate. Now, of course, those of you who've looked at the legislation will appreciate that these three verbs, which are so important, are not defined in the legislation. But in a case in the family court, the then president of the family division, Sir James Mumby, looked to the standard Oxford English Dictionary definition of mutilate when he was asked to deal with this question in family proceedings, and found that that is to deprive a person of the use of an organ by dismemberment or otherwise. Terribly helpful, but that's as far as we've got. So that is the definition of the offence. However, no offence is committed by an approved person, and an approved person is defined, and that of course will include medical practitioners. So no offence is committed by an approved person who performs, firstly, a surgical operation on a girl which is necessary for her physical or mental health. Now, again, that's going to be, I'm sure, subject to litigation in the future. What's meant by necessary was something we argued about in Dharmasena, so I'll return to that in a moment. But again, physical or mental health is not defined in the Act. So what do we mean by that? Do we mean serious physical or mental health? Do we look to the Abortion Act? Where do we go to find a definition of that? These are all open questions. So if you're a medical practitioner, you don't commit an offence if it's necessary for her physical or mental health, or secondly, if it's an operation on a girl who's in any stage of labour, just given birth, for the purposes connected with the labour or birth. And just finally, what I want to say about this, those exceptions, so those two aspects of the medical practitioner, either it's necessary for physical mental health or it's connected with labour and birth, they are exceptions, they are not statutory defences, and that's something that Dharmasena made clear. And finally, I should just say this, that the Act makes it clear that when determining whether something is necessary for the mental health of a girl, it is immaterial whether she or any member of her family, for instance, believes that that operation or procedure is required as a matter of custom or ritual. And that is explicitly made clear in the Act.
Thank you very much for that, Zoe. That was extremely helpful. Now, turning to prosecutions in the UK, those of you that are interested in this topic, it will not have missed you that just last week was the very first successful FGM prosecution in the UK. There have been 4 attempted prosecutions by the CPS to date, but only one has resulted in a conviction. Now, Zoe is going to come on to talk about Dr. Dharmasena in due course, but he was one of the first prosecutions of a doctor, and he was charged with performing FGM on a new mother. There was a lawyer who was accused of beating his daughter and arranging FGM as a punishment, and he was charged in 2018 and was cleared of all of those charges. Now, the trial which commenced at the Old Bailey in the last month was a trial in relation to a 3-year-old girl. Now, the charge and the conviction was against her mother, and part of the defence was that she had fallen onto metal and that had caused the injury to her vagina. Now, that was obviously rejected by the jury as her mother was convicted, 37-year-old woman. Now, her partner was not convicted, and it will be interesting to see when the law reports come out about that as to the basis as to why the jury did not find him to be guilty in relation to the offence. Now, as we were just talking about very important cases, Dr. Dharmasena, and this was a case that Zoe was absolutely pivotal in. So I'm going to turn over to the expert to deal with the background to this, and I'll be chipping in with some questions to Zoe in the course of that.
Well, perhaps the first thing to say is that Dr. Dharmasena was acquitted in 5 minutes. So for all doctors out there, that's encouraging. But what was far from encouraging, what was deeply disappointing, is the CPS's decision to prosecute this doctor. My own view is there was a degree of political pressure, because at that point no one had been charged with an offence of FGM, and the Home Affairs Select Committee was asking Alison Saunders just a few days before Dr. Dharmasena was charged why that was. And also, I'm afraid, it's an example of the Crown Prosecution Service not really having investigated the case properly before deciding to charge. So, Dr. Dharmasena was a young doctor. He was a registrar at the Whittington Hospital. The patient, who's obviously been anonymised, we called her in the case, and I'll call her today AB. She was a woman born in Somalia, and whilst living in Somalia, she had FGM type 3. So just to remind you, that is the appositioning of the labia so that the vaginal orifice is really occluded and there's just a pinprick, and indeed also the urethra is also occluded, and so the urine trickles through. It's a very serious form of FGM. She came to this country as a refugee, and in 2011 she went to the Kingston Hospital on the NHS and had that type 3 infibulation reversed. I use the word reverse advisedly because you cannot clearly put it back to what it was before. But basically, it was de-infibulated, so the vaginal opening was revealed. So that happened in this country in 2011. And sadly, the CPS had not got those records and had not appreciated that when they charged Dr. Dharmasena, which was a fatal error. Anyway, we know that the de-infibulation was successful because very shortly thereafter, AB got pregnant. She was in the catchment area of the Whittington Hospital. Unfortunately, the midwives failed to appreciate her history. She should have been put on the FGM pathway, but she was not. And it's a little difficult to understand why. I think from my understanding of the case and reading the evidence, one of the major problems was, contrary to good practice, she was not given the benefit of an interpreter during her prenatal visits, and so she would often come with members of the family, which puts certain inhibitions on things. And also, she cannot have been examined properly by a midwife who was trained in FGM, because she would have seen the labial scar tissue, which was the result of these two procedures that this patient had.
Zoe, just in relation to that, how much of an element did that become in the later litigation, that failure for the patient to be put on the FGM pathway?
It was quite considerable, because it meant that when Dr. Dharmasena, who was just happened to be on duty the day AB went into labour, he had no idea of her history, because of course it wasn't contained within the records, and so that, from his perspective, was very important, because he'd not been forewarned, he'd had no opportunity to take advice, so it was important. And of course, it was a midwife who raised concerns after the procedure, which I'll deal with in a moment, and not wanting to be too indelicate, but this trial clearly became something of a battle between doctors and midwives, which was unfortunate, but that's what happened. Mm-hmm. So then moving on, so AB went into labour. She found herself under the care of Dr. Dharmasena. As I've said, he had no understanding of her history, and things became quite difficult, because the labour became protracted. The fetal heartbeat started to cause concern. And when Dr. Dharmasena first saw his patient, the head of the baby had pushed so far down that that had a distorting effect on the vulval area, and in particular had meant that ability to get to the urethra was very difficult because of the position of the baby's head. So this eventually turned into something of an emergency situation. This baby had to be delivered quickly and by instruments. And so what Dr. Dharmasena decided to do, quite rightly, was first of all to make a 1.5 centimetre cut in the anterior midline. The purpose of that cut was to expose the urethra, because of course, as all doctors listening in will know, you cannot embark on an instrumental delivery until you have catheterized the patient. So he had to do that. It was a 1.5 centimetre cut. That was successful. Catheterization took place. The delivery occurred, and during that there was an episiotomy. Baby, I'm pleased to say, safely delivered. So it is what happened after that delivery that caused him to find himself in the dock at Southwark Crown Court.
I'm just stopping this. In relation to up until this point in the delivery, had the midwife who eventually made the complaint been present throughout the whole of this time?
She'd been in and out. She'd been in and out. But interestingly, Dr. Dharmasena was accompanied by another, even more junior doctor who was observing. And so what happened after delivery was that Dr. Dharmasena asked this junior doctor to stitch up the episiotomy, which she did. She took quite a long time over it, but that's probably because it wasn't something she was particularly familiar with. And then after that had happened, Dr. Dharmasena appreciated that that other cut that he had made to reveal the urethral opening was still oozing blood. And this was about 20 minutes after the baby had been delivered. And so it was his judgment that he should stitch that cut up. And what he did is he brought together, don't forget this is 1.5 centimetres, brought together the two edges of the cut, and at the apex put a single figure of 8 stitch in. And that single stitch, figure of 8 stitch, was what the prosecution alleged amounted to infibulation. So he did that. The midwife said, don't think you should have done that. I think that's contrary to the law on FGM. Dr. Dharmasena went and sought advice from his consultant, and his consultant said, and this really was echoing what the Royal College guidance was, that in fact Dr. Dharmasena should have stitched those two edges separately rather than just bringing them together at the apex in the way that he did. However, the consultant said, leave it, it's fine, she's not bleeding anymore, why cause further distress and discomfort?
And in terms of expert evidence that was then available at the trial, did the expert for the CPS echo that same view that the consultant had to Dr. Dharmasena about the manner of stitching?
Yes, so the prosecution's expert agreed that the stitching should have been on each edge separately, and that the appositioning at the apex of the two areas could amount to infibulation. And really the heart of the Crown's case was that subsequently a midwife went to see this patient, standard postnatal procedure, and the midwife gave evidence that she examined the patient and that the vaginal orifice had been sealed as a result of this single stitch. However, we were able to demonstrate that that simply could not be right, because the patient had no difficulty in sexual intercourse thereafter. Indeed, she quite quickly got pregnant again and had a second child without any intervention whatsoever. And moreover, she had no urinary tract problems or issues. So the weight of the evidence was very much against that midwife's testimony, but her testimony was critical.
And in terms of the patient, how much of the feature was her evidence at the trial?
Well, that was a very interesting point, because the patient wanted nothing whatsoever to do with this prosecution. She was extremely happy with Dr. Dharmasena. He had, after all, safely delivered her of her first child. But this was where the CPS perhaps made a rather major tactical error, because they could not call the patient, because the patient, as I said, was not supportive. Now, as you may appreciate, Dr. Dharmasena wasn't the only one in the dock. There was another individual in the dock, and reporting restrictions mean that we can't identify him. But if I say that he, this co-accused, called as part of his case the patient. And so this was a wonderful strategic decision, which both defence counsel decided upon, because obviously you don't call a woman who has been subjected to FGM in the past, which she obviously had been, likely. But what it meant was that we forced the Crown into cross-examining the so-called victim of FGM, a very awkward position for the prosecution, and that was, again, another aspect that didn't go well for them. But if I may, I think there are two aspects, legal aspects, that have a real resonance with doctors that I just want to touch upon if we have time. The first is that issue about infibulation, because that was the prosecution's case, that Dr. Dharmasena, by stitching in the way I've described, infibulated the patient. And there was an awful lot of discussion during the course of the case about what that meant, because as I've said, there's no definition in the Act. And we looked to the WHO definition, and our argument was that if you take a purposive or literal definition of infibulation, it must include the sealing of the vaginal orifice by appositioning either the labia minora or majora. Now, the judge, Mr. Justice Sweeney, wasn't very keen on that argument, and indeed he refused our argument at the close of the prosecution case and at the close of the defence case, that if that must be what infibulation means. And so that was a real area of concern. And if we end up with doctors finding themselves being charged with FGM and the Crown rely on mutilation, again, there's a similar problem, lack of definition. And the only other matter I want to just touch upon, because it was a live issue in Dharmasena, and it's going to be a live issue in any future cases, is what is meant by necessary. Because again, in the criminal case, we were trying to import those ideas of necessary that those of us who practice in the medical regulatory forum understand. That is, a reasonable body of competent doctors would consider that necessary. But the judge in this case was not prepared to import that regulatory understanding of necessary, and wanted to bring in really a sense of essential to the definition of necessary. Now, we argued against that, but that again is something that is not defined, and I think is an area for future debate.
Thank you so much, Sally. That was really, really helpful. Now, the guidance around FGM for clinicians, there is some guidance. The NHS England has a mandatory reporting duty flowchart, but in essence, since October of 2015 in England and Wales, there's a legal duty to report. That relates to known cases of FGM in girls and young women under 18. Yeah. But where a woman is over 18 and either discloses or identifies that she has had FGM, no such legal duty exists. And there, a clinician should follow the local safeguarding processes. So in Dr. Dharmasena's case, I'm assuming that that was a step that was missed before this patient gave birth, because there was no feature of that in her medical records. Would that be right?
Yes, that's right. And of course, the mandatory duty to notify, which is a GMC duty, if you observe FGM, or if a girl, because we're talking about under 18s, if a girl informs you of FGM, that was not in force at the time, because of course we've got to remember that Dr. Dharmasena was charged with an offence that occurred in November of 2012, and that didn't get to trial, I don't think, until about 2014 or beginning of 15, I can't remember now. But the mandatory duty, which has been brought about by the Serious Crime Act 2015, that was subsequent to it. But there were still, I mean, there were still safeguarding duties. But you're right, he was never criticised for that, because, of course, it hadn't been flagged up.
Absolutely, thank you. Now, we're going to talk about emerging trends of vaginal surgery, because that is one of the issues that will almost become live in that fourth category of potential FGM. But I just wanted to ask you, we've talked already about the fact that there's only now been one successful prosecution under the legislation, and you almost started at this point about the cultural shift towards FGM, and that perhaps there was some pressure to Alison Saunders at the time in relation to lodging the prosecution against Dr. Dharmasena. Do you think that cultural shift has continued in relation to this topic?
I do, because if you read Hansard, and if you look at the voices coming out of Parliament, what the parliamentarians are saying is, look, we cannot be prescriptive in the United Kingdom and say that it is an offence to cut, infibulate, or mutilate a woman, if at the same time we are allowing women to go to a clinic in Harley Street and for purely cosmetic purposes get cut or mutilated. And that's been a really strong message that is coming out of Parliament, and I see no sign of that diminishing. And what they want to do is they want this to be, as it were, culturally neutral. And so that is why girls in this country who have piercings, clitoral piercings, labial piercings, a doctor has a duty to report if they're under 18, because that amounts to FGM. And so this is a real area, and personally speaking, and I've had to advise a cosmetic surgeon already, this is an area that's beginning to become more and more problematic, and I think this is an area where doctors who practice here in cosmetic surgery are at risk, because of course if you're working in the realm of cosmetic surgery, there is a real question about whether you can say that it is necessary for a woman's medical, physical or mental health if a woman is coming for purely aesthetic reasons, asking for labial surgery.
Now, in relation to that, you've touched on something that I was just going to ask you about. Do you think there need to be, at some point soon, some legislative changes around the law on FGM because of this very nature of emerging trends of vaginal surgery, or do you think the legislation as it's drafted is sufficient?
That's a difficult one. I think the legislation as it's drafted is sufficient for its primary purpose, which is to capture individuals, such as that very recent case that we heard about last week, which is the sort of case that this legislation was designed to deal with.
Absolutely, that was a real FGM
That
case.
was a real FGM case, whereas nobody could suggest that the case of Dr. Dharmasena was a real FGM case. But as with so much legislation, is unintended consequences, and I think that's the problem. I fear that we won't get any refinement of this legislation until some poor cosmetic surgeon has found him or herself in the dock. And I think the fundamental problem with it is the failure to define those critical verbs, particularly infibulation and mutilation, because cosmetic surgery is really going to come under mutilation or possibly excise, cutting as well. And so we do need refinement for that, and perhaps we need an exception that deals with cosmetic surgery. But the problem with that is that that's very much contrary to the legislative tone at the moment.
That vaginal cosmetic surgery is one of the most growing areas of cosmetic surgery, and that these are the three types that are mainly referred to. So the labiaplasty is the labial or lip reduction, and then you've got the vaginoplasty, which is vaginal rejuvenation or vaginal tightening, and then you've got the hymenoplasty, which is hymen repair, which that is an area which is quite linked to FGM in some cases. So Zoe, what do you think is going to come out of these trends?
Well, of those three, the one that is particularly liable to prosecution is any individual who undergoes labiaplasty. And I know that the Crown Prosecution Service have looked at individuals practicing labiaplasty and are continuing so to look. And from my personal involvement, I know that one case was possibly not pursued because there would have been a reasonable argument that it was necessary for this female's mental health. But in many of them, that will not be available as an exception. And so I know that the Crown Prosecution Service are looking at those cases very seriously. And I think now they've got their first FGM prosecution under their belt, which, as you rightly said, Shannon, was what most people understand to be what this legislation was designed to capture. I think there may be a momentum and an impetus now to go after somebody who has performed, in particular, labiaplasty.
Around this area of labiaplasty, if a cosmetic surgeon gets that knock on the door from the police in relation to this area, what do you think the CPS are going to be relying upon in kind of that physical and mental health? It's going to come down to expert evidence, isn't it?
It's going to come down to the notes and expert evidence. And so, as with so much in medical practice, I appreciate that busy practitioners on the ground, this is a real pain. But if you find yourself in a legal situation, notes, comprehensive notes are absolutely critical. And making sure that if you are a cosmetic surgeon, have turned your mind to the offence of FGM and asked yourself the question, and you probably have to get advice about this. Am I about to commit an offence of FGM, or do I come under the exception that it is necessary for the girl's physical or mental health? Now, as an example, in a case where I was asked to advise, that cosmetic surgeon had been sensible enough in securing a psychiatric report on the female in question to assure himself that it was necessary for her mental health. Now, that's pretty much as good as you can get. Of course, that's not conclusive, because it will very much depend what is contained within the psychiatric report. And there'll be lots of cases where you wouldn't dream of sending an individual to a psychiatrist. This is really difficult. If you are about to engage in a procedure whereby you cut or you infibulate, appreciating the difficulties with that, or mutilate, and there is a real question mark about the necessity of that, you are at risk of committing an offence of FGM.
Now, many cosmetic practices have counsellors that are attached to them that give pre-surgery counselling. And my understanding of those individuals, they're not necessarily healthcare practitioners themselves, such that they are on a register like the GDC or the GMC register. But what do you think about using their notes and their expertise in these circumstances as a potential to a defence around that kind of physical and or mental health aspect?
Oh, the notes of a counsellor would be better than nothing, but it's not a get out of jail free card by any stretch of the imagination. Because at the end of the day, the duty lies with the practitioner, and there may be issues about relying on counsellors whose understanding of this area may be wonderful, but maybe limited. And as I've said, the difficulty with this is the Act does not define mental health. And so there's a real argument here. Does that mean just a sense of unhappiness with a physique, or does it have to be something as significant as gender reassignment? And there's such a spectrum of what affects a woman's or female's mental health, and I cannot answer, Shannon, where on that spectrum a prosecution can succeed or fail.
Absolutely. Well, I agree with you entirely that I think we're going to see more prosecutions in this area, and it will be interesting to see how the area develops now that there has been that first prosecution, although not in relation to a healthcare practitioner. Now, moving on to kind of fitness to practice proceedings around this area. Now, in Dr. Dharmasena's case, what, if any, aspects of the GMC proceedings play for you?
Well, fortunately for Dr. Dharmasena, after his acquittal, the GMC decided not to proceed at all. And that was very reasonable and fair. There were one or two minor things that they could have picked up on, but there were no GMC proceedings. But there, I think there has been at least one case in the GMC.
So in 2012 that we've got on the slide there was a doctor and dentist, respectfully, that are on the DC and GMC registers, who were arrested for offering to perform FGM on two young girls, and they were exposed by the Sunday Times journalist at the time. However, there was insufficient evidence to charge them with the crime. As we know, there's only been one successful prosecution so far, but they were subject to fitness to practice proceedings by their regulators, respectfully, and both were struck off by their regulators. Now, this is one of the issues that often comes into play for practitioners. If there are criminal proceedings running, the regulator may send you that letter, and they invariably do, saying we've had a report about you. And it can be very difficult, because if there is a criminal investigation rumbling on, the regulator is very loath to do anything in that time, because it may jeopardise that criminal prosecution that's ongoing. What, if any, advice do you have to practitioners about how they juggle those concurrent proceedings?
Well, as you've rightly recognised, Charlotte, the practice is that the criminal proceedings have precedence over regulatory proceedings. That's not going to change, and I actually think that is, in fact, in the best interests of the practitioner. The downside, of course, is that criminal proceedings can take a long time to come to court, and of course a practitioner may be subject to conditions or even suspension in the interim. So that's the downside. But the upside of dealing with things in that order is that inevitably the criminal proceedings means that the practitioner's defence team will secure expert evidence, will have full disclosure from the CPS, And those aspects are critical in not just a criminal case, but in any subsequent fitness to practice proceedings. And so, although it's takes a long time, and I appreciate frustrating, my personal view is that that is the right way to deal with it. And then when the regulatory proceedings come to fruition, the team is fully equipped to deal with it.
Absolutely. Now, we've talked around the subject quite a bit, but there are obviously some tips arising out of the subject that we've discussed. Now, one of the things that I wanted to talk about, and you've already touched upon it, is the issue of notes. Now, every regulatory criminal lawyer will say to a healthcare practitioner that your notes are absolute gold when it comes to any type of litigation arising out of your practice. Is that something that you echo?
Absolutely. I have been involved in so many cases where a practitioner has been hoisted by their inadequate notes, whether that be in GMC or indeed in criminal proceedings. And so the notes, you cannot underestimate how important they are. And I always say to practitioners, of course we understand that you're busy, so you're just putting a little aid memoir for yourself down, but go back to it. Go back when the clinic is over or when your operating list is finished. I know it's another thing to do and to remember, but go back and just add a bit more detail. Time it, make it clear that these are retrospective notes, but the detail is critical. It's not just going through the standard points about notes, history, examination, It's about your reasoning. And if you put down your reasoning as fully as you can, that is going to make things so much easier for the practitioner, whether it be in the GMC or in the Crown Court.
Absolutely. Clinical reasoning is find about on a regular basis. That if your clinical reasoning is clear from any notes that you make, that almost cannot be argued with because it is evident on the notes why you have done what you have done.
And can I just say that you're absolutely right. And the reason why it's difficult to argue is it's contemporaneous. And so often practitioners are accused of post-event reasoning to try and get themselves out of a sticky situation. If it's there in black and white on the day, you're safe.
Absolutely. Now, one of the things that can happen, you touch upon this, is interim orders. So you've got a criminal prosecution that is going on, regardless of whether it's about FGM or not. And then there is that letter saying that you've been invited to an interim orders panel. Now, what advice would you give to clinicians in preparing for that, when realistically the criminal prosecution is kind of in its very early stages? So it's very difficult to tell what's going to come out of them.
It's very difficult. I mean, the first thing is you must always engage. And I find that, let's say it's the first time a case comes up, the individual presenting for the GMC will not have a lot of the evidence. Will often just have the police case summary, which are notoriously ill judged and incomplete. They sometimes have witness statements, sometimes they don't. So I think what you need to do is to be realistic about what is likely to happen, and that will obviously depend upon the nature of the accusation. Be proactive, so if you think that conditions are a likely outcome, we'll go ahead and organise some conditions that are practical. And the most important thing is, do not make yourself a hostage to fortune in anything you say in any correspondence early doors with the GMC. That's quite important. I say that not because that is necessarily admissible in the criminal court. 9 times out of 10 it would not be. But if things evolve, of course it's admissible in front of the GMC.
Absolutely. The other type of evidence that can be very helpful at an interim orders panel things like the appraisal, the last appraisal, which shows how well you've been doing in practice and the type of issues that you've discussed, testimonials from colleagues that know you and know your practice and know your ordinary conduct that can say good things about you. Also, even though a case such as serious as FGM, making sure that the panel know that you're up to date with your CPD, so you are taking your practice seriously, because revalidation is a real live issue. Making sure that practitioners are up to date and are fit to practice. It's long gone are the old days where you just had your registration and you didn't really need to do much other than submit a cyclical form in relation to your CPD. The other thing that clearly we are going to say as lawyers is that you engage a lawyer, because that is a very important step. What do you think about that, Zoe?
It's critical, because, as I've said, there are so many areas at the beginning of any proceedings, whether they be regulatory or criminal, where an individual doing the best he or she can is liable to trip up, and that can have a real negative effect later on down the road. So yes, get in touch with your MDU or MPS or whoever you are, whichever organisation you're a member of, and that's so important, and do it straight away.
Absolutely. Now, have you got any closing remarks, Ellie, on this topic?
Well, I think from a lawyer's perspective, what I would simply seek to reiterate is that the Crown Prosecution Service's appetite to prosecute further cases is undiminished, that those practicing in cosmetic genital surgery need to be very, very careful indeed. And the difficulty with that is that, as I've indicated, rather unfortunately, so much is still unresolved as to definition. And I fear that that will only come about if there's a successful prosecution that is appealed, and then we might get a bit more assistance.
Absolutely, absolutely. So thank you everyone for joining us on this webinar. It will be available on the Kingsley Napley website for you to listen to in due course. And that goes out to the people that are not listening live at this moment in time as well. There will be a link available so that you can hear what we have discussed this evening. This has been such an interesting topic, and I really thank you, Zoe, for coming in and giving all of your expertise in relation to this particular topic. I also have to thank our marketing manager, who is in the room with us, Deepika, who has made the technology all possible and easy for us to do this. And thank you very much, everybody, for joining us. Thank you, Zoe. Thank you, Deepika.
Thank you very much.